Hello, everyone. Welcome to Washington Gun Law TV. I'm your host, Washington Gun Law President William Kirk. Hey, listen, we get calls all the time at Washington Gun Law with questions from people like you who have questions about your Second Amendment rights or other issues related to firearms. Don't ever hesitate to give us a call. If you have questions, feel free to call us at 425-765-0487. But today I want to talk to you about perhaps one of the most common questions I field on a daily basis almost. And it's this question, which is, hey, I want to sell one of my hunting rifles to my brother-in-law, or I need to sell, I want to sell a shotgun to my uncle. Do I need to go down to an FFL and conduct this sale through an FFL and have a background check conducted on that person? And the answer is very dependent upon the relationship between the person who is selling the firearm and the person who is purchasing the firearm. And so today we're going to spend a little bit of time talking about Washington's efforts back in 2014 to close the gun show loophole and what it means to you. So let's talk about the history behind this law. Some of you may recall Initiative 594. It was back in 2004, and it was labeled as closing the gun show loophole. It was a very significant piece of legislation, though, on a national level, because Washington State did become the first state in the entire country to mandate background checks for a certain class of private sales. And that led to the creation of RCW 9.41.113, which is the applicable statute which we're going to be talking about today. Now, that statute specifically states that all firearm sales or transfers, in whole or in part in this state, including without limitation, a sale or transfer where either the purchaser or seller or transferee or transferor is in Washington, shall be subject to background checks unless specifically exempted by state or federal law. So the importance of this statute, as you can see, is that for the first time ever, a state was requiring background checks to be conducted on all firearm sales, even those between private citizens. The law further goes on to state that the background check requirement applies to all sales or transfers, including, but not limited to, sales and transfers through a licensed dealer, at gun shows, online, and between unlicensed persons. Now, one of the reasons that this statute was created to begin with is there was, for all intents and purposes, a gun show loophole in certain situations. And what we mean by that is this. An individual could walk into a licensed FFL, a place such as a Cabela's or something like that, attempt to purchase a handgun. They would fill out the form, the ATF form 4473, a background check would be conducted, and perhaps that individual would not pass the background check. In some situations, that person would not pass that background check because they should not be passing that background check. They have prior felony convictions, domestic violence convictions, or any of the other multitude of disqualifying events that would preclude a person from having a firearm. Cabela's would, of course, then deny that individual the sale. Prior to the passage of Initiative 594, an individual could theoretically then walk across the street to a gun show at the fairgrounds or something like that, find the exact same firearm for sale through a private seller, and be able to purchase the firearm without having to go through a background check. The purpose of Initiative 594 and RCW 9.41.113 was to preclude that from happening. There are three types of sales that the statute contemplates. Now, the statute essentially says that no person can transfer or sell a firearm unless, one, the person selling the firearm is a licensed dealer, or number two, that the person who is purchasing the firearm is a licensed dealer, or in the event that nobody is a licensed dealer, that all requirements of subsection 3 of the statute, which again runs you through the mandatory background checks, have in fact been satisfied. Now, the question we get all the time at Washington Gun Law is someone calls, they want to sell a firearm or they want to purchase a firearm from a friend or family member, and they want to know, do we have to go to an FFL and conduct a background check? RCW 9.41.113 subsection 4 does exempt certain relationships from the requirements of having to do a background check. So therefore, if a person is selling a firearm to any one of the following individuals, a background check is not required: spouses, domestic partners, parents, parents-in-law, children, siblings, siblings-in-law, grandparents, grandchildren, nieces, nephews, first cousins, aunts, and uncles. Beyond that relationship, if they do not fall into any one of those relationships, if you are selling a firearm, you must go through an FFL and have a background check conducted on the purchaser. This could be your best friend, your lifelong friend, the guy you grew up with your whole life, the guy that you go hunting with all the time, that you know is absolutely lawfully allowed to have firearms and probably has several already. You still must go to an FFL and have the background check conducted on them. Finally, there is this issue, which is if you are making a private sale and it falls under one of these exceptions to the statute spelled out in subsection 4 of 9.41.113, should you go to an FFL and have the sale recorded anyways? Well, many people do not realize this, but in the state of Washington, whenever you purchase a firearm, whether it's a handgun, rifle, shotgun, whatever it may be, when you go through the FFL, the state of Washington Department of Licensing will in fact be notified that you have purchased that gun. And I can't tell you how many times when I have individuals who are accused of crimes in which they have to forfeit their weapons, we get a printout from the prosecuting attorney that comes from the Department of Licensing that shows each and every firearm that they have purchased in their life, and therefore they are presumed to be in possession of each and every one of those firearms. If I was selling a firearm to a family member or a friend or whatever, I'd still want to go down to the FFL, have that recorded with the Department of Licensing so that that firearm is no longer under my name and that the serial number is now recorded with the new owner. Well, I hope that answers some of the questions that you may have about private sales and when you actually need to conduct a background check. Listen, you may have a lot more questions about this or any other issues related to firearms or your Second Amendment rights. If you do, don't hesitate to give us a call here. You can always visit us at washingtongunlaw.com. You can give us a call at 425-765-0487. You can email me directly at william@washingtongunlaw.com. Listen, part of being the responsible and lawful gun owner, like what we preach here at Washington Gun Law, is knowing what the law is and how it applies to you in each and every instance that you may find yourself in. Until next time, thanks for watching and stay safe.